Welcome back to this final panel, and we have lots of time, but there's a natural ending to this panel, and that is the fact that we will be kicked out of the building at 6 o'clock because of the weekend. So we'll take that into account and have a good discussion before, and of course, for those people that are not online but present in the room, we can continue the discussion during dinner. No worries there. So we start off with Alessandra Gianelli, who has been writing on customary law and the European Union for many years. She did a book, and what was it, 2014, you said?
2004.
2004. So she was one of the first people actually addressing this topic and is now revisiting the topic. So, Alessandra, we're very happy that you're here. You're a professor of international law at the Sapienza University in Rome, and the floor is yours.
Thank you very much. I would like to join the previous speakers in thanking the conveners of this workshop, and particularly for engaging me. This is a topic I have not gone back to since a long time. So this was really a great chance to just gather some thoughts again about the topic. The only problem was that it is during the semester, so these thoughts are kind of not particularly well articulated. But I maybe belong to that first generation of students, people who try to study and make sense of this topic. And because I'm Italian, I come from a strong school. To me, one of the main problems was, but is this a subject of international law or is it not a subject of international law? And the way one would answer this question would probably solve some of the problems, like the question you have asked. Is it binding for the member states that they approach the European Union, judges or political institutions take about the development of customary international law? It depends. If it's a different entity, it's not binding insofar as the member states act outside of European Union law, while it is binding if it is something which is connected to European Union law. But of course, this is kind of the end of the question, not the beginning. Is it or is it not an international person? And by that I mean something different from the sum of the member states. In any case, I have easily agreed with the proposal for this workshop, which accumulated the European Union judiciary to what I would call a national-like entity. That is, to a court or system of courts, I just refer to a court for brevity, which is applying its own law, and which takes into consideration international customary law as something which is outside, maybe, but comes inside, so I don't know how that plays, inside its legal system. I would say that the question seemed much more ethereal 20 years ago because there was no Lisbon Treaty, there was no Article 3, Paragraph 5, no Article 21. So why the EU court decided that it was bound by customary international law was much more, an arcane. Why? It would call upon that article concerning invalidity where it says that the court is entitled to evaluate the validity of EU acts in view of any rule of law. Any rule of law to the court would include customary international law. So that just think how far we are from the situation as it is today. I also found very stimulating the stress that the Panos put on the development of international law. Not only the TEU states that the EU shall contribute to the strict observance, but also to the development of international law. So I thought this was rather a unique case. I don't know of any other constitution or constitutional practice which would openly allow whichever in the legal system to develop international law. So given this very specificity, one more note. I agree very much. I agreed 20 years ago. I even agree more today that the courts act here as national courts. So these, what does this mean? That all the observations taken during the codification of the ways to identify international customary law concerning international organizations really would not apply to the European Union if it's something more like a municipal-like entity rather than an international organization entity, then maybe, but naturally to the extent that we think it's a different person, maybe all the concerns of the states, because from what I could read, it was really the states, not so much the Commission, who were against including international organizations' practice in the relevant practice for the development of customary international, then those observations would not apply. It's a different person. It's not a way to circumvent the fact that each state is a single state, and then when you add the European Union, the 27 are really 54 because they can count twice. No, it's just a different subject. But anyway, given these, I also would like to make another point clear. While, as I said, I agree perfectly on this view of the judiciary, EU judiciary as municipal courts, there is, however, even if very much in the background, a line of cases which still takes into consideration customary international law as something which interfaces with the treaties, with the establishing treaties. I had found at the time something vague in Van Duyn, I'm in Holland, Van Duyn, okay, about the duty of a national state to readmit its citizen according to customary international law. I have found another case more recent in Hungary versus Slovakia, where the Court of Justice says that the position of the head of state is different from any other EU national because there are rules of international law which address the topic, and so the president of Hungary cannot invoke the freedom of movement to have his entrance into Slovakia allowed in any case. So I do think that there is still, it doesn't come out very often, but it's still there. There is something which has to do with the establishment, should I say, the volet communautaire, meaning that the treaties, still are treaties to some extent, and they still relate to customary international law, even if remote cases, but you see, they come up somehow. Okay. I was very happy to see this opportunity of hearing more than talking, because I've been interested lately in the idea that customary international law may be interpreted and not only identified. And I thought that, this was a good occasion, good chance to think about this. Maybe differently from what I wrote in my short written presentation or abstract. Reading the cases, it seems to me that it's not, when we have talked about this earlier this morning, we say, how does the court identify customary international law? Does it talk of practice, of opinio juris? No, it does not. What does it do? It refers to a codification convention, to a judgment by the ICJ, maybe to something else, General Assembly resolution, self-determination, and so. But this is identification. Interpretation, to me, seems to, it was this development of international law which made me think, this interpretation is more linked to the fact that you have the rule, you identify the rule, and then you have a case which is not your straightforward case, but is a case which has something which is not quite in line. So there you have to apply the rule to a case which is not specifically that case. Then comes in interpretation, according to me. And of course, at this point, interpretation and development become strictly connected. While I was looking at methodologies, which methodology does the Court of Justice employ, certainly one distinction is maybe the international courts apply a certain kind of methodology and the Court of Justice employs another one. But is it really so or not? Do these two courts, just to take the ICJ and the CJEU, really do a completely different job? We know what it's written in the ILC project. Court, and we teach this, courts may significantly contribute to the development of customary international law. Okay, by their first duty, and it's very clear according to Article 3.5, their first duty is to apply customary international law. For that part, the operation the Court of Justice carries out is just the same that the International Court of Justice carries out. It applies the rule to a specific case. Then, if the case, as I said, it's not so simple, then here we are in front of the possibility of developing, interpreting, or other. I then thought about the problem of the direct effect of customary international law. Is this a way to interpret customary international law which is proper of the European Court of Justice, or is it not? Is it relevant at the international level how the European Court gives or gives not direct effect to customary international law? I answer myself no and yes. No, why? Well, first of all, I am a public international lawyer, so I'm not a European Union lawyer. I think that self-executing, direct effect, and what is the other, directly applicable are three different concepts, even if they are strictly connected. But they are three different concepts. So, how would be the practice of qualifying a certain customary rule as having, in the terminology of the court, direct effect or not? Would that be relevant in the sense that that rule should be considered as having direct effect for other courts, for other countries? And I answered no. Why no? Because to me, the idea of self-executing international rules is not an abstract matter. It's a matter which must be decided in each case, having in front the content of the customary rule and the way the municipal system is at that precise moment in time. Only then you can decide whether that rule is or is not self-executing. So it's not something you can decide for everybody. It's a decision which must be reached at the municipal level every time a court has to apply a customary rule. So no, I mean the fact that the Court of Justice decides that a certain rule has or has not a direct effect is not really relevant to me at the international level. What is, however, relevant, this is the yes part, yes answer which I gave me, is the fact that by doing so, though, the court has internalized custom. It applies to custom the same criteria which would apply to other EU rules. So by this way, what does this mean? That maybe there is, I'm Italian, I'm a dualist, and so forth and so on. It has transformed this international rule into an internal rule. So that to me was more interesting. The fact to decide whether the customary rule has or has not a direct effect is old. Rake was about this, And the interesting thing is that the Advocate General in RACE, which was Jacobs, looked at the member states' practice to see whether there was a common trend which could be applied to the system of European Union law, and it did not find it. It said each state has different ways to approach the adaptation of its system to customary international law. So it seems to me that this says something about the methodology of interpretation. It's an internal EU rule. I will apply EU rules of interpretation. Okay. I'm almost done. Okay. Sorry. So the cases I ran through 20 years ago were Pulsen and Diva, Open Austria, and RACE. Those were the cases. There was no CADI, there was no Lisbon Treaty. I've written on CADI, but there was no CADI at the time, nothing. So, but those cases already concerned the claim of invalidity of Institutions Act because of contrast with customary international law. And what is important to me is that even then, even if in the end it did not annul any, in RACE particularly, any act, it, however, did say that it was looking into this customary rule to see whether it had those characters which could be invoked by. It is funny, we were talking about misinterpretation, and given the time, I won't go back to that. But it is funny to me that once we have a codification convention, rebus sic stantibus has all its paragraphs, and the court still says it's a vague rule. It doesn't say it's a political question. The decision may be one for the political institutions. No, it says it's vague, really. It doesn't have any of the features which would allow an individual, a private party to claim an annulment action about that. So because my time is going out, I do think, however, I would like to add something else. Is this, in this case law, which many times is not, one cannot agree with the solution of the from Polisario saga, where the court says that, says something which doesn't have any standing in international law. If the treaty has been applied contrary to a jus cogens rule, something has to be done with this treaty. It's not that we can say, this treaty is perfect, just forget about that. No, this is a cause for invalidity, so we should do something about this and not just set aside the part we don't like. However, having said that, what I would like to add is that actually, even going back to these old cases, this case law is significant. When it's significant as it is today. Why? Because when the court says Article 18 of the Vienna Convention reflects the customary rule. Now, today we can all agree, but in 1969 it was not something which was completely agreed upon. It's partially good faith, but partially development of customary international. So the court says that, good, this is contributing to the development of international law. There is now, we know that even this court recognizes that there is this rule in international law. So I'm sorry, I have not been very articulate. These cases really call for a lot of remarks on the merits of how the court reaches its conclusions, but it seems to me that, for example, even the Sea-Watch case, which is one of the last ones, the fact that it keeps saying that these are customary, the SOLAS, the SAR, these are all customary rules. No, this is contributing to the development or ascertainment of customary international law. This is what the court does. It says, I apply these because are rules of international law. Thank you very much.
Thank you very much, Alessandra, for this very interesting overview indeed, which also confirmed sort of the things that we heard throughout the day. There's a bit of cherry picking by the court, but at the same time, there's some kind of confirmation every time the court does something, it contributes at least to something. So that is interesting, and I'm pretty sure that we get back to that point, but we now move to Mark Konstantinidis, who co-authored his paper together with another good colleague, Takis Tridimas, at King's. Mark is at King's. You're a visiting lecturer there, but you're also at UCL, for instance. So you have many different positions, and this is also one of the topics that you work on, and you bring us back to the Vienna Convention, in fact, and the interpretation of that, if I understand correctly.
Yes, thank you so much. Thank you so much for having me. It's an honor to take part in this workshop. I will be presenting a paper which Takis Tridimas and I have been working on, though I should say, obviously it's very much work in progress, so any comments would be very appreciated. Our focus is essentially on how the Court of Justice has engaged for interpretive purposes with customary international law, in particular the law of treaties and the Vienna Convention. First, let me say a couple of words about the status of customary international law in the EU legal order, the relation between the two more broadly, though this has been covered, so I won't already, so I won't dwell on it too much. On the one hand, obviously we've seen that the court has asserted the systemic distinctiveness of the EU from the general international legal order. The EU is a new legal order. It stems from an independent source of law. This has also been systematized into a constitutional principle, that of the autonomy of the EU legal order, which effectively asserts both the interpretative kind of autonomy of the legal order, but also the Court of Justice's own jurisdiction. On the one hand, the EU is is constitutionally committed to the strict observance and the development of international law under Article 3, Paragraph 5, TEU. This includes EU concluded international agreements, but also customary international law and Jus norms. The court has long established that EU institutions are bound by international law. But what does that mean exactly? I mean, there's clarity with regards to international agreements, not least following the seminal Hegemon judgment, where the court found that international agreements form an integral part of union law so far as they constitute, from an internal kind of EU perspective, an act of one of the EU institutions. With regards to customary international law, things are perhaps less clear. In Cadi, the Court of Justice, as all of you know, found that it cannot assess the compatibility of an international act, an act of international law, by reference to customary international law, including Jus norms, but it did not preclude the possibility of an EU act being reviewed by reference to customary international law. And the court suggests that in this judgment and judgment like this, an evasion of directly addressing the relationship between the EU legal order and customary international law, although it has approached kind of doing so in Rakia and so on, but in Western Sahara, Front Polisario, etc., it did not suggest that directly that there was a breach of customary international law by EU institutions, which would have compelled it to crystallize what sort of binding effect international law has on the EU institutions. And this approach maintains a sense of ambiguity as to the status and effect of international law within the EU, and allows the court to exercise for interpretive purposes, as we'll see, some discretion, shall we say. To aid our exploration, we have carried out a statistical analysis, very preliminary, as you'll see, of ECJ and General Court case law, where the customary international law or the Vienna Convention are referenced, including judgments, orders, opinions of advocates general and the court as well. The chart on the left, the chart on the left shows that the overwhelming majority of CJEU references to the Vienna Convention or Customary International Law have been made by the ECJ in judgments and opinions rather than the General Court. The charts on the right show the historical trend of judicial engagement with customary international law, including the Vienna Convention. And there's a clear upwards trajectory, in particular with regards to the ECJ. Of course, this is qualified by the fact that the volume of case law of the court has itself increased. But still, that nonetheless shows a willingness to engage, even in the context of the sort of engagement that the court carries out, as previous panels have discussed. Also, there seem to be almost double as many opinions of advocates general as ECJ judgments which refer to the Vienna Convention or customary international law, and that signals an openness. One might speculate in terms of motivations, but it does signal an openness on the part of advocates general compared to the Court of Justice itself to reflect upon a broader range of legal sources when considering the relevant questions. But in proportionate terms, the court does seem more open to doing so, and for reasons that are quite straightforward, with regards to review of envisaged international agreements under Article 218, paragraph 11 TFEU, so where the court has to render opinions following a request by member states and or EU institutions. Of course, that only amounts to 2.6, I think, roughly % of total ECJ references, but there aren't that many opinions in the first place, so I think in proportionate terms that is significant. In this light, we consider the court's engagement with customary international law for the purposes of interpreting international agreements. In Opinion 191, the Court of Justice considered the compatibility of the judicial mechanism envisaged under the proposed EA agreement, and the EA was intended to be established on the basis of rules which were textually identical to those of the then EC treaty, but the court found that this similarity is not sufficient because an international treaty is to be interpreted not only on the basis of its wording, but also in the light of its objectives, and it effectively compared the object, purpose, and context of the proposed EA agreement with the then EC treaty on the basis of Article 31, paragraph 1 of the Vienna Convention. This was followed in cases such as Metalsa, Edlin El-Yassini, Gianni and Hergatna and Gassa, and a few more. This approach is followed where there is a claimed textual equivalence between provisions of an international agreement on the one hand and usually the EU treaties on the other hand. El-Yassini is an exception to this. So what is the object, purpose, and context of EU treaties? I mean, that can be a conference on itself, but they're not just economic in nature. They rather provide for integration, which is connected to the telos of European unity. They're not just an international agreement, of course they are, but also they establish a constitutionalized legal order which is based on the rule of law. They're not just intergovernmental, they effect a transfer of sovereign rights to common institutions. They provide also for fundamental freedoms, including the free movement of persons as discussed in El-Yassini and Hergatna and Gassa. This gives rise to a methodological paradox. Jurisdictional openness, the application of customary international law by the Court of Justice, contributes to a sense of jurisdictional protectionism, which is the assertion of the distinctiveness of the EU. It signals an intention to reconcile the systemic distinctiveness of the EU legal order with the EU status as a subject of international law, and indeed engagement with the Vienna Convention in these circumstances is an effort to accommodate the Union's uniqueness within the ordinary framework of international law, and as such, the Court's approach can be said to accord with the twin objective of Article 3, Paragraph 5 of observing and developing international law. What about cases where there's no textual similarity between a provision of international agreement and the EU treaties? The court's approach in these circumstances also seems to be dependent on procedural and substantive considerations. With regards to the preliminary reference mechanism, the court's approach is likely to depend on the nature of the question referred to it by national courts. First, if the question is one of mere interpretation of international agreement provision, the court seems able to engage in many cases in a conventional, shall we say, orthodox application of Article 31 of the Vienna Convention. For instance, in Waltz, regarding the Montreal Convention, the court offered a uniform and autonomous interpretation of the term damage, which was not based on any kind of EU law understandings thereof. In AEPTRI and more recently OBB, the court extensively engaged with Article 31. I mean, with no apparent diversion from international interpretive orthodoxy, or at least not to the extent that one might have otherwise expected. Secondly, if the question is one of compatibility of an EU act with an international agreement, the approach seems to be different. In cases like IATA and Alpha, the ECJ, for example, was asked whether provision of a regulation on the rights of passenger in that instance was compatible with the Montreal Convention. And by referring to Article 31, the court emphasized the consumer protection kind of aspirations of the convention, ultimately finding that there's no incompatibility. So this was an application of the Vienna Convention which was rather accommodating. This is probably the third euphemism I've used so far. But it ensured that the union's legislative capacity is, in the circumstances of these particular disputes, not restricted. The Western Sahara judgment, for example, might also be considered in these terms. Of course, one might say, but what about Comstroy? It does not seem to fit with this categorization. The Paris Court of Appeal asked the Court of Justice to clarify the definition of investment under the Energy Charter Treaty. The ECJ makes no reference to customary international law when answering this question, unlike in cases like Waltz. Instead, the ECJ interpreted the concept of investment under that international treaty in almost exclusively textual terms. And substantively, it found that a claim on the basis of an energy supply contract cannot constitute an investment. And I think it's important to note that this does not seem necessarily inconsistent with international law. The Advocate General did engage with international law criteria, arbitral tribunal awards, and reached the same conclusion. So even where the Vienna Convention is not explicitly engaged, this does not necessarily lead to interpretive outcomes which are incompatible with international law. But still, this is not just about outcome or methodology. Referring to the Vienna Convention can be taken as an acceptance of the jurisdictional limits of the EU legal order. Comstroy reveals the court's sensitivity to the broader signaling implications of referring to principles of international law, and doing so would amount to a qualification of the interpretive or conceptual autonomy of EU law, which in the circumstances and in light of the particular subject matter of Comstroy, which is investment arbitration, it may also be perceived by the court as a partial kind of concession of its own jurisdiction. So these considerations may well trigger a reflex of disengagement, even where the question referred is one of mere interpretation. About annulment proceedings and infringement proceedings, I think it's fair to say that the pattern does not seem to be easily identified in the same way. Perhaps by nature, due to the nature of annulment proceedings, the court might feel more able to engage with a broader range of provisions of the Vienna Convention, as well as other principles of customary international law, because annulment proceedings require a review of validity. They're not just about interpretation. And infringement proceedings might be also affected by not just the circumstances of each case, the arguments of parties and so on, which are of course very important, but also by the Commission's enforcement priorities. Lastly, the customary international law is also relevant for the purposes of interpreting EU law. namely, the court seems to have established a duty of harmonious interpretation vis-à-vis international law by analogy with the duty requiring interpretive consistency between national and EU rules, in line with von Colson and Marliesing. For the EU lawyers in the room, virtually or physically, that's a very kind of a standard fundamental principle, which nonetheless seems to have some salience in the international context. But in the international context, Paulsen noted that the European community must respect international law in the respect of its power. EU law must be interpreted and its scope limited in light of the relevant rules of international law, which include customary international law as codified by or expressed in international agreements. This has been reaffirmed in judgments like Commission and Germany and Hermes. So in principle, I mean, prima facie, that type of, the Paulsen type interpretive duty seems far-reaching. And when talking about the Vienna Convention, it might provide for an extended role for the Vienna Convention for the purposes of interpreting agreements to which the EU is not a party, but which nonetheless bind the EU because they express customary rules. This has been recognized in principle in Intertanko. Nevertheless, in practice, so far, such an indirect effect of international agreements seems quite limited. Firstly, the court seems to have preserved considerable discretion over the extent to which it will pursue such a harmonious interpretation. The Paulsen type duty is not formulated as prescriptively as its internal counterpart. In Pfeiffer, for example, consistent interpretation of EU law and national law was connected with the effectiveness of EU remedies, and so there is no equivalent constitutional imperative for the development of a Paulsen duty vis-à-vis international law, which is equally intense with that under von Colson or Marliesing. And the objective of interpretive consistency between EU law and international law does not seem to be in itself sufficient in that regard. In her opinion in Changmao, Advocate General Chapeta argued for a restrained approach in the court's pursuit of consistent interpretation between EU law and international law, with a view to not restricting institutions' scope for political maneuver. So we see that this discretion afforded by the formulation of the Paulsen duty might even depend on extra-legal considerations, and that's probably my fourth euphemism. Secondly, the Paulsen duty is limited to the very requirement of customary of the customary status of rules, unless we're talking about an agreement to which they use a party. For instance, unlike in Mondier, in Intertanko, the relevant international instrument was not considered to codify customary rules. So this suggests that something that's worth exploring further is the way in which the court, in these circumstances, chooses to identify customary international law. To conclude, the court seems to treat the relation between EU law and international law as a balancing act between jurisdictional coherence and normative openness. With regards to the interpretation of international agreements, European uniqueness is paradoxically asserted through its normalization by reference to international law. The court's engagement with the Vienna Convention seems to be affected by procedural and substantive considerations, and also there seem to be overriding factors relating to the autonomy of the EU legal order, which might affect the perceived legitimacy of some rulings, notwithstanding perhaps that the outcome might be in congruence with international law. And lastly, the interpretation of EU law along the lines of what Paulsen suggests would be able to provide some flexibility by way of reconciling the systemic distinctiveness of the EU legal order with respecting international law. Thank you.
Thank you very much, Mark. Very interesting presentation again, and food for thought for the discussion later on. When I was looking at your statistics, I thought, well, okay, you seem to relate the number of times that the court actually referred to the VCLT to the openness. But of course, it very much depends on what the court actually said about the VCLT. But the rest of the story was about that it's actually very positive. Whenever it refers to it, it's actually to adopt the rules rather than to say we're stressing our autonomy, we're not interested in the VCLT at all. So that was interesting, and this short interlude also allowed the next presentation to be set up by Teresa Cabrita, postdoctoral research associate at Leuven at the moment. You're working there. Of course, previously you were at Amsterdam. That's where we know each other from. Actually, we met in Utrecht first, but that's another story. So the floor is yours. You will partly discuss also the Vienna Convention, but mainly will focus on the EU's role and perhaps within the EU, even the legal services, we'll see, right? In the UN Sixth Committee and also the ILC.
Thank you very much. I would like to obviously thank the organizers for inviting me and giving me the opportunity to contribute to these debates by bringing somewhat of a different angle to this discussion. So I look primarily at the role of EU legal advisors within the Commission Legal Service that are responsible for preparing and delivering EU statements at the UN Sixth Committee, as Ramses just said, on the work of the International Law Commission. I like this topic apparently so much that I wrote an entire PhD on it. And while in my abstract you'll probably see something very broad about everything the EU has ever said under the sun on the VCLT, I actually decided, because I quite like storytelling, to bring you back to a story in the 1970s, which is the first time the EU, at the time EEC, ever made comments on the work of the ILC. And it did so in the context of very specific debates, which were debates on most favored nation clauses in trade agreements, which sounds incredibly boring, but I hope to try to convince you in the next 10, 15, I hope, minutes about the relevance of this as an illustration of how EU legal advisors actually advance an interpretation of rules of customary international law, at least in the context of these debates. So what I'm going to try to do is essentially explain a bit my main argument or context against which my paper is couched, very briefly what these debates were about at the ILC, and importantly, how legal advisors of the Commission Legal Service, at the time your EEC Legal Service, engaged with these debates, notably the three things that really caught their attention. And then obviously how the EU's interpretations of rules in the context of this project were received or not, and some conclusions that we can derive from it. So my main take, and the reason also of this paper, is to illustrate how EU statements on the ILC's work, which were qualified by one EU legal official that I had the opportunity to interview in the context of my research as diplomatic discussions about legal matters, actually offer an interesting interpretation sometimes of rules of also customary international law. They position the EU with EU practice in the process of development of rules of international law, or shelter it from these developments. The paper focuses on MFN clauses, but the take is that this was the first engagement, but it has ripple effects because the EU has engaged since consistently with the work of the ILC. And I have examined the 11 different topics on which this engagement has taken place that include a lot rules of the VCLT, obviously, but also extend to the expulsion of aliens, crimes against humanity, protection of the atmosphere, and for law of the sea scholars in the room, sea level rise in relation to international law is currently being discussed at the ILC. The EU has already started making statements, and by the few discussions I had with EU legal officials since, it will most likely keep on making statements very actively. So a lot to come. So ILC debates on MFN clauses started with this guy, Jiménez de Arechaga from Uruguay, who was a commissioner at the time, and he really tried to push for this to be discussed within the VCLT debates back in 1964. The Commission generally thought that, yeah, this is very interesting, but it warrants independent study. So the study actually was carried out between 1967 and 1978 by two special rapporteurs, both of which were diplomats, Endre Ustor from Hungary and Nikolai Ushakov from the then USSR. It ended all in 1978 with 30 draft articles on most favored nation treatment in treaties between states, which, as you will see, it's the EU's first point of contention. And quite a lot of considerations concerning the effects of economic integration of both developing but also developed or industrialized nations on the existence, emergence, and development of rules of customary international law. Now, what makes these debates quite interesting is not just the fact that it was the first time the EEC had something to say. It had just acquired UN observer status back in '74, so it joined the debates. But these were also debates that were couched against a particular historical and political context. There was a process of decolonialization ongoing, the new economic international order movement, and Christian Tomoshat referred briefly to these debates at the LC as actually falling on the negative side of the balance sheet. For, in his own words, being conducted under the suspicion of opening up the advantages and established among community member states to third states in the absence of reciprocity. So as essentially to socialist states. And if you happen to be fascinated with the topic or incredibly bored, and if you read the debates, this really comes out, which makes the debates quite interesting. So the EC's engagement started in '75. First statement ever was by Mr. Hardy, and as you can notice, he was the observer for the European Economic Community. And he spoke immediately after the Italian delegate that at the time had the presidency of the Council. At this time, he was speaking at the invitation of the chairman. So basically, the community and its member states really teamed up for this project. And essentially, community legal advisors had three, let's say, issues with this particular draft. On its scope, and then rules on economic integration for developing countries, which legal advisors were really in favor of, so strongly endorsed, and the rules on economic integration of industrialized countries, the so-called customs union issue that the community was very much against. When it came to scope, and I'll keep this brief, in essence, for the community and its member states, namely the statements from Luxembourg and the Netherlands at the time, they were quite upset that the draft was limited to states. And community legal advisors essentially advanced a doctrine of state assimilation of the community at the time. They said, basically, international lawyers at the LC should interpret state as also encompassing an entity that exercises powers in the relevant sphere, because this was a sphere in which community legal advisors, well, the EEC at the time already had exclusive competence. Perhaps unshockingly, this was not very well received at the LC. This goes back to debates that started very early with the LC, and then Endre Ustor was actually quite open to this idea of including groups of states. He referred to the community as a hybrid union. Nikolai Ushakov, not so much. At the LC, the debates concluded with essentially a commentary. This is quite common practice of the LC, a commentary to the end, where it said, well, we're referring to a clause on most favored nation treatment, and this is broad enough to also include other subjects of international law and can even at times, depending on practice, be referred to most favored international organization clauses. So this was how the LC solved the issue. The community legal advisors were not particularly pleased, but they went with it. What they found to be more interesting were actually two sets of rules, both of which touch on economic integration and its effects on the development of custom. When it came to developing countries, there were two articles, 24 and 23, and also Article 30. Essentially, this project was developed with the idea of creating rules that would protect the position of developing countries, that would allow them to increase economic integration amongst them, but also to not be excluded from benefits by virtue of economic integration by industrialized states. And the community was actually quite pleased about this. And today we spoke about how the confirmation is a way by which the court also contributes to development customary international law. And this is one example of how legal advisors do so. In further projects referring to the VCLT confirming its rules, EU legal advisors are very good at it. In this particular project, it was interesting because they really advanced EU practice as confirming the existence. And in fact, because these rules were really tilted towards the progressive development of international law, they present the EU, and this is a term that has been referred to today, this is conference bingo, about 5 times, which is the EU as a trailblazer in international law. They relied on EU practice essentially as confirming this rule within the GATT, within the Leuven Convention, also the general system of preferences accorded by the then community to 77 countries within UNCTAD. This said, and going back to Thomas Schatz's words, legal advisors were a bit concerned about one of the articles in the text, and so they advanced a different article that would also essentially protect community advantages from different, as they call it, different socioeconomic systems, which essentially they said we should have most favored nation treatment also to the benefit of developing countries, provided that when it comes to different socioeconomic systems, equitable distribution of advantages and obligations of comparable scale are always ensured. So far, so good, but actually the most problematic issue in these debates is the so-called customs union issue. Customs union are, as juridical categories, exceptions from most favored nation treatment. And there was an article back at the beginning in the draft, Article 16, that became 17, because the ILC goes through so many processes, that essentially said that the position of third states should not be affected by the conclusion of bilateral, multilateral agreements between the granting state and other states. The question that arose was whether or not intra-customs unions benefits would be automatically excluded from the reach of most favored nation clauses. Now, the fact that they were generally excluded was really not being contested. I mean, the GATT recognized this, it was common practice in states' practice. The issue was whether or not there was an automatic exemption. The customary international law had developed to a point where, even in the absence of an express exclusion, this would be granted. And importantly, although I will not touch upon this in detail, whether or not this was desirable or actually led to most favored nation treatment being devalued under international law. Perhaps unshockingly and surprisingly for the community, it was really important to have a rule that recognized an automatic exemption for customs unions. And legal advisor essentially advanced, again, a new article, which, if you look at the debates in the last 50 years, does not happen very often. Legal advisors do not come up with formulations of rules of international law. There were 2 debates where this has been most prominent, and as I argue in my own work, it's situations where there's a perceived greater interference of international law within the constitutional structures of the EU legal order. The 2 cases, unshockingly, are MFN and ARIO. So basically, they proposed an article that would essentially say, regardless of the rules of this text, nothing should affect the rights and obligations within customs unions. And to do so, legal advisors advanced 2 types of arguments, one community-specific and one international specific, let's say. The community-specific one is, again, unsurprisingly, revisiting the language of the Court of Justice in Van Geneloos and Costa Vienel, and also relying on the EC community treaty. At the time, it was 234, now 351. And essentially, what legal advisors said was the special nature of the regional integration process in which community member states have engaged is completely contrary to the non-recognition of an automatic exemption for customs unions, because the rights accorded between member states, the privileges, are indissociable from the obligations, including jurisdictional monopoly of the Court of Justice, which now we are, academic circles are quite delightful to speak about. What I find actually more interesting is how legal advisors engaged with the language and legal reasoning of public international law. Now, caveat here, in the 1970s, public international lawyers were not a strange sight in the Commission legal service, so I think that this is one of the reasons why, perhaps in these debates and also on the ARIO, you really see this shining through. The arguments advanced in this respect were mostly to try to convince states and lawyers at the ILC that the community was one example among many of a trend towards regional economic integration. That was not only seen in the global north, but it was also transcending to CARICOM, to ECOWAS, and so forth. In addition, legal advisors tried to express the view that Article 14 of the GATT confirms this exception, and because it confirms this exception, it has replaced the general rule whereby you actually need an express exemption. And the third point was the fact that you have no practice in international law whereby a third state acquires all the benefits within a customs union or free trade area confirms the existence of a rule. Conclusions. ILC decides to not necessarily include a customary union exception and simply say that the non-inclusion shall not be interpreted as an implicit recognition of the existence or non-existence of such a rule. Outcome and conclusions. In this particular project, the ILC has relied on communities' interpretations of or readings of customary international law. It relied on community practice to support one of the more progressive development of international law articles. But as was also already mentioned today, in some occasions, the EU was seen as too specific. But this is a point that I make more in my PhD, for policy rather than practice reasons. The ILC's general attitude towards the community and later the EU has been to have this more broad, all-encompassing approach, which you can see both in the definition, in the commentaries of the scope of the draft, and the customs union exception. Community was not pleased about this. This is actually the first, one of the most stern languages ever used by the EU in engagement with the ILC, where it concludes that even if there was only supplementary nature of these rules, it would never be accepted by the community unless the rules constituted a well-balanced set of rules, which as a whole reflected practical reality. This is a point that you only see again in the ADIO, fast forward a few years later, and with a slightly more diplomatic language. Conclusions. My spiel is essentially for the relevance of other actors beyond the Court of Justice that largely rely on the Court of Justice case law, but do so in different venues and in dialogue with international actors directly in the language and following the legal reasoning of international law, their relevance towards developing an EU position and interpretation of rules of international law, including customary international law, as I hope this illustrated. It does develop a concrete influence, in this case, Articles 1, 24, and 17, and has set the stage for a lot of the debates that you now see with Michael Wood, you saw, ended in 2018, on the role of the EU in the expression or development of rules of custom. The role of regional integration has been a dominant feature since. So that's it. Thank you so much.
Thank you so much, Teresa, for your nice presentation. And I'm sorry for rushing you a bit, but I think we got the main points. And it's very interesting also to see that something that we actually hoped for, that as lawyers, that we actually have an influence in those bodies as legal advisors if you're working there. So that's great to see that. We have a bit of time for discussions, for questions. So let's say about 10 minutes or so. So I gladly open the floor to anyone raising points on those two presentations by Mark and Teresa. Jed, please.
Hi, it's Jed. My question's for Mark on your project, which has some overlaps, I think also methodologically. One is you mentioned Comstory as an example of where the court could have engaged or dealt with customary international law but didn't. And how do you deal with that as a part of your methodology of, because I'm facing the same thing, where it could have or may have used international law interpretation principles without ever mentioning the VCLT, and why you mentioned that case as an example. And also, I'm trying to think of how this can be a question on Comstory, that yes, it didn't use the VCLT when it was interpreting what investment was under the Energy Charter Treaty, but then it's also part of a broader discussion about Vienna Convention, because in all these other arbitral tribunals that have dealt with the Comstory/Achmea argument, these tribunals do use VCLT. They often come to the conclusion based on Achmea and Comstory are not useful or relevant because of the application of those Vienna principles. So are those decisions developing customary international law in that area? And maybe could that be a reason why the court, for instance, is not engaging with things like the Vienna Convention in those cases? So I think that's a question as well.
Thank you. I don't know.
Yes, my question is for Teresa. This is an incredibly interesting story that you are uncovering, and I was not familiar with the EEC's participation in the debate on MFN. And I was just wondering if in your research you got a bit of a sense of how it has come to pass that the EEC has decided to take that first step into really participating in codification under the auspices of the UN, because there were some other projects more or less around that time that would have been of interest to an international organization like the EU or the EEC. But you see, I see here that it has chosen, of course, to pitch in a project that refers to trade and, of course, to one of its core functions and missions. And I was just wondering whether that story, whether there is a story there to begin with, and whether you could comment a little bit on that at all.
I have one question for Mark. Two questions, sorry. The first one is, I'm not sure, maybe I got this wrongly. I think you applied Article 31 to the treaties themselves, right? Article 31 of the Vienna Convention. And my second question is, how does misinterpretation fit? Because I saw the statistics with the engagement with international law, but this does not say something about what kind of engagement with international law we have. Thanks.
Anyone else? André? Mm-hmm.
Yes, André de Hoog from the University of Groningen. Question for Teresa. I noted that the EC was arguing that the MFN rule would be replaced by the exception of customs unions or free trade areas. And that kind of goes to something which has come up before, which is, how do we actually see an exception? An exception can be kind of something excluded from the scope of a rule, or it could act as a kind of justification for conduct otherwise inconsistent with the general rule, for instance. And I'm kind of wondering, because if we're talking about MFN clauses and a rule of customary international law, it depends on how you formulate the MFN rule in the first place. And of course, if it's a customary rule, it would apply to all states in the world. So it seems a bit tricky to have an exception that would simply replace the rule because you choose to replace it, if you see the point. I quickly took a look at Article 24 of the GATT to see how it's formulated, and it basically says, well, the provisions of this agreement shall not prevent the creation of customs unions or free trade areas, provided that, and then of course certain conditions come. Now, in Turkey textile, the court basically said, well, you can invoke a free trade area against a claim of violation of the MFN clause, but only if you conform to the conditions of Article 24. Which doesn't quite tell me, how we see the exception. Do we see the exception as replacing the MFN rule altogether, or do we see it as an exception of a limitation of scope of the MFN rule, or do we see it as a kind of justification for conduct otherwise inconsistent with the MFN rule? The reason why I'm saying it is because the EC seems to have a specific idea in mind, namely the MFN rule is replaced by the customs union exception or something like that. So that's what I was kind of wondering, whether they had a specific idea behind talking about the replacement of the rule.
Thank you very much, André. I think this is about the time to turn to our panelists and perhaps to give Teresa a bit of time to think about this last question. Turn to Mark first on anything you want to read.
Sure. Thank you so much for your questions. Firstly, about Comstroy. So indeed, the court could have engaged in Comstroy with the Vienna Convention and did not. How does this fit with the methodology that we're discussing? I think it illustrates its limits, which is to say that even where you have the court is faced with a question of prima facie mere interpretation, which is not relating to the compatibility of an EU act with international agreement. And in those circumstances, usually the Court of Justice does seem to engage with the Vienna Convention. I'll come to what form that takes in a bit. When there are concerns about the autonomy of the EU legal order, such as those kind of being triggered by investment arbitration, then even that approach reaches its limits, it seems. This does not seem to me to be a far-reaching kind of pattern. It seems to be specific to this judgment, really, and that's why it's so shocking, and it's an outlier that can't not be addressed. But I think the answer to this is to treat the categories as indicative clearly, or to consider the autonomy of the EU legal order as kind of an overriding factor. About the tribunal's use of Vienna Convention in effectively disregarding Comstroy, I think in this regard it's important to note that Comstroy is about two things. Firstly, and technically that should be the only thing, but if one considers the referred question, it is about the interpretation of investment. So that is about Article 31 of the Vienna Convention. The second thing is the thing that the Court of Justice kind of worked its way towards, which is the compatibility of intra-EU arbitration on the basis of the Energy Charter Treaty with EU law. It is on that point that tribunals use the Vienna Convention as a way to assert their own jurisdiction. So it's not on the matter of the substantive interpretation of investment. Of course, that also says something about the court's engagement or lack thereof with the Vienna Convention. But I think it's more complicated. Again, it fits under the umbrella of autonomy, where all bets are loose. And it is the Commission that seems to be trying to do the work in justifying Achmea, Comstroy, and so on in terms of international law. In terms of its effectiveness, the modernized ECT does provide for a carve-out for intra-EU arbitration. So policy will find a way until it doesn't, which is the problem with the modernization. But anyway, with regards to the application of the Vienna Convention, we're not considering their application on EU treaties, but rather on international treaties on the one hand, and then, so EU concluded international treaties, and on the other hand, EU law by way of the duty of interpretation. How does misinterpretation fit in? It's absolutely true and a fair point that the statistics don't show the whole picture. I think that's undeniable. It's very difficult to quantify engagement. That's not to say that it can't be quantified. The way we try to account for that is we also have some disclaimers on the paper in terms of methodology with regards to the statistics, but the way in which we try to qualify that is through qualitative kind of analysis of selected aspects of the case law. But at the end of the day, I think misinterpretation is also engagement, and there can be lessons learned from that as well. And it does tell us something, and as Ramses said, and identified, I think correctly, when the court refers to the Vienna Convention, it seems to be doing so in order to apply it or even misapply it, but very rarely to say that it has no relevance. So ignoring it is a question of omission rather than engagement.
So very quickly, first, thank you so much for engaging in further questions. First question from Fernando, how did it come to pass? The EU's engagement with the ILC was referred to by one legal advisor as being guided by a fingertip feel more than a formal strategy. At least this is also how I interpret it in my own work. In essence, I fully agree with you. I don't think that there's not a precise systematicity to the EU's engagement, and I would refer to, in that respect, to the lack of an EU engagement with reservations to treaties, which, oddly enough, is something that, for instance, Frank Hofmeister has noted that EU practice really develops the behavior of its own member states internally, but then the EU makes no comments when this matter is being discussed internationally. But it is generally based on an assessment on the existence of competence, precedent, whether or not the EU has said something in the past, and importantly, and this is, I think, it's where the diplomatic aspect comes into play, it is based on also whether or not there are legal developments within the EU legal order that the EU can showcase internationally to states. So EU statements on the expulsion of aliens, initially the EU was not even participating in the project, but then the return directive was adopted. And then the EU had a lot to say about this project. So I think all of these aspects kind of conflate. And the other aspect is a more socio-legal one. I think that the existence within the Commission Legal Service of certain lawyers that also drive this process has played a role. I think when it comes to the ADIO, this is a clear case. And the ADIO has been seen, for instance, as one instance of engagement where path dependency was established. Now they actually, at the Commission Legal Service, they have someone that always follows ILC debates. And my understanding is that the EU wants to engage more and more because it's one more venue where they can explain. And I think it's actually a particularly good one because it accords. The statements are oftentimes vague. But it is one venue where you can get into the nitty-gritty of public international law and actually discuss the existence or emergence of rules of custom, which, with the exception of other things that are actually not very public, like CADI meetings, or obviously amicus curiae briefs and the Court of Justice itself, you don't have a lot of these venues. And in the Court of Justice, I mean, you're not discussing with international lawyers, you're discussing within your own EU bubble. So it's a specific case. So that would be that. I'm happy to talk about it endlessly, actually. And when it comes to exceptions, I'm not sure if I can answer this question adequately. So when it comes to exceptions, first, EU attitude on exceptions to general rules has been twofold. You have the attitude in this project, which was the EU really saying that, in fact, this is not an exception. This has become the rule. There's a rule of customary international law whereby customs unions, intra-customs union benefits are excluded, period. So it's no longer an exception. And then you have the general position of the EU when it comes to exceptions, which are to carve out the space for the EU. ADIO is a clear example. Specific rules on competence-based responsibility. There's endless number of examples. When it came to the project on MFN, what the community legal advisors wanted to do was to limit the scope of most favored nation treatment, so that it would not encompass these inter-customs union benefits that in any case would be excluded based on the EU treaties. Curiously enough, and I think there you pick on something that goes in line with something that was said here today, which is interpretations of customary international law by all actors are ultimately self-serving ones. And in this particular case, I mean, there's a performative function that is being done here, right? And the community statements do refer to the GATT, quite sometimes, Article 14. They do not refer to the conditions whereby exceptions are allowed under the GATT. So that's it. Thank you.
Thank you very much, Teresa. And this brings us to the end of this workshop. And now you're obviously waiting for my 30 minutes wrap-up, which is not going to take place. I just wanted to take a few minutes to first of all thank all the presenters for being here today and sharing their very insightful thoughts on a very interesting topic, I think. I wanted to thank Panos for the excellent cooperation that we always have, but I will do that tonight. And that leaves me then to thank the excellent TRICI team that has always been, yes. Also to you, Konrad. We have many of these workshops, and during the TRICI-Law project, we had seen they're excellent already in organizing these things. And this was actually the very first time that we cooperated with EUDIPLO together. And both projects are running towards their ends, so we will not have these projects again cooperating. We will find many other opportunities to do that.